Law School, and she started out her career at an international law firm, which many of you may know, Greenberg Traurig, representing large companies. So like many of us, started off working with the big guns and then decided that there was something out there and she kind of wanted to do it her way. So since then, she launched Corp Law. And Corp Law helps modern entrepreneurs like ourselves protect their business, specialize in working with locally small business owners here in the South Florida region. So Kristen has received numerous distinctions. She was named South Florida's Outstanding 40 Lawyers Under 40 by the Cystic Fibrosis Foundation, Rookie of the Year by Greater Miami Chamber of Commerce, and also earned a Rising Star distinction by the Florida Super Lawyers. She's currently the president of the Dade County Bar Young Lawyers Section, which is the largest voluntary association of lawyers in South Florida. So in addition to running her own law practice, she does dedicate her time mentoring students, and she teaches law and business to undergraduate and graduate level students at FIU. She is the founder and the brains behind an innovative community-based initiative, Sidebar, which brings together lawyers and other legal professionals to collaborate and drive change in the legal industry. Kristen has a special respect for working females and female minority-owned businesses, as she was raised by a single mom who ran her own business. So thank you, Kristen, for joining us today and donating your time. And without further ado, I will pass it over to you.
Thanks, Annette. That bio was perfect. It leaves me without too much to say in my own introduction, but let me first start by checking, can everyone see my screen okay? I'm sharing some PowerPoint slides. Perfect. Would not be the first time that I've done an entire presentation thinking that everyone could see my slides and not learning until the end that they could not. Okay, just get set up here. Perfect. So, like Annette said, my name is Kristen Corpian. I have, at this point, been practicing law for 7 years, and my focus, my passion, is working with small businesses, startups, and especially female and minority-owned companies to help them ensure that as they're building their empire, whatever that may be, that they're protected on the legal side of things. I also do teach part-time. I enjoy working with undergraduate pre-law students, and I have in the past also taught at the law school level. Formerly, I worked at a large corporate firm working with the big companies, companies like Walmart, HBO, but truly for me, the passion resides in working with the small business owner. There's no doubt that the big companies deserve representation and they pay well for it, right? But for me, I realized, I think within 2 weeks of working at a large corporation and what many lawyers feel like is the dream job, that it really wasn't my flavor of ice cream and it wasn't the dream for me. So I'm excited to speak with you all and share as much as I can about what you should know at the intersection of business and law. To that end, one of the things that you should know is that lawyers are restricted in a lot of ways in terms of what we can and can't say. So while I am a lawyer, I'm technically not your lawyer. And so disclaimer 101 is I'm going to talk about a lot of different things today here in a very high level general sense, but the Florida bar restricts my ability to make any specific representations unless I am, of course, your lawyer in general. And so the takeaway point is while I'm giving high level information, you always want to consult with your own attorney and make sure that you're operating on advice that is specific and custom tailored to you. That being said, usually when I'm in a room full of folks, I can get a better sense of how they're feeling about speaking with the lawyer. Here I can only see a couple of faces. I promise I'm going to try to make this a bit more interesting, even though we're talking about legal topics. I realize that most people, and kudos to you for being here, don't have much interest in hearing what lawyers have to say. I embrace this fact and do my best to kind of operate around it and prepare a presentation that can be interesting generally, even though we're talking about that not so sexy topic, which is the law. I think that it's important to note that lawyers have a personal why too. At the corporate side, the corporate level, I don't know that it's something that's focused on too much, right? We don't much care about lawyers' personal why, just that they do a great job with their writing and protecting us. But I think it's important to highlight that lawyers aren't robots, we're people. And as you are selecting the lawyer and the law firm to represent you or a friend or family member, you want to think through this important piece. There are a lot of unhappy lawyers, right? And so I think it's really important to connect with those who love what they're doing and they're passionate about it. Annette actually provided a little bit in my bio about my personal why. I was raised by a single mom who she raised me and my sister off of her business and just kind of watching what that meant, her small business, for my family, the freedom and flexibility that it gave to her as a mom to be there with us when she needed to be, but also the pressure and the toll that it took on her, and just how fierce she was to make it work for so many years really left an imprint on me as a person. And I don't think that it really started to take effect until I started working for someone else as a young woman and realizing, wow, it's been ingrained in me since a very young age, entrepreneurship. And now, interestingly, both myself and my younger sister own our own small businesses. So for me, the personal why comes from watching someone who I love very much work very hard for a long time. To that end, what are we going to cover today? A lot in a small amount of time. I actually just did a 6-hour presentation for an accounting firm in the Bahamas to them and to some of their clients. And we talked about all of this stuff. And even in the 6 hours, it wasn't enough to cover everything. So there's a lot at the intersection of business and law. I'm going to do my best in broad strokes to cover a good amount of those things. In general, incorporation, IP, contracts, growing your team, what you should know in terms of the employment side of things. But understand that each of these topics can be the subject matter for a full course or a couple of years worth of courses at the law school level and in the continuing learning level. Also, when I'm speaking with a group, I can kind of gauge or take a poll on, am I speaking with folks who've never heard any of this before, or am I speaking with folks who are maybe a little bit more advanced in their knowledge? So here I'm going to assume that we're in the 101 kind of spot on this. And so forgive me if I'm repeating something or simplifying something that you already understand very well. During the Q&A, if you want to get into the more advanced topics, to the extent that there's time, perhaps we can do that then. But I'm going to assume that I'm presenting this material to someone who's never heard it before. So bear with me if you're one of the more advanced consumers of this information. All right. What entrepreneurs should know about business law? There is a lot, right? We're talking regulations, employment, contracts, evidence, procedure. There's a lot more than what's listed on this list here, so much that I think it's information overload. And before we dive in, I think that we should hit this important point. When you start a business, even if it's a business of one, right? You're a solopreneur, you are the master conductor of that business. And so before we dive into a lot of content, let's get mindset right. And that is, you can do this. We're going to talk, what might feel like Greek, but as the master conductor, you cannot abdicate your responsibility to understand the law. And I think that you know that. That's why you're giving at least some time listening to what I have to say. But I think coming at this from the appropriate mindset is really important, because whenever most people are faced with something that they don't like or that doesn't interest them, their brain shuts down. For me, that's accounting, right? Some of the darkest days for my business were when I tried to be my own accountant. That's why I outsource it and have somebody who actually enjoys and loves looking at numbers do that for me. Nonetheless, it's important to have a general sense so that you, as the master conductor of your business, can ensure everything is in place. And even if you're delegating the role of legal and HR and accounting, if it were, you know enough to ensure that your business is getting what it needs to thrive. To that end, the top highlights that we're going to hit today are incorporation, IP, employment, contracts, and then this concept of dispute resolution and maybe this weird word of torts. So for incorporation, I'm going to run through this one fairly quickly. Usually the first question that's asked is, why incorporate my business? I perhaps have a client or two. They're willing to pay me to offer some services. Maybe you don't want to invest that money in actually creating an entity. And so why incorporate? Usually the number one answer to that question is because incorporating a business at the state level gives you the limited liability protection. So that is to protect your personal assets and keep them separate from that of what the business is doing, from any potential business liability. And it's a really powerful shield. I call it a shield, even though you're not going to actually visibly see a shield. There are other reasons to incorporate, but usually this is the number one reason. If you're working with a great accountant, which we highly recommend, they've probably already suggested this. Perhaps they've even done this for you. Incorporating an entity is certainly something that if you're looking for DIY options, you can do yourself. You should think through some of these questions as you are deciding whether or not to incorporate and if you are going to go ahead and incorporate. So what are the goals of the business is always number one. Because if you are, let's say, looking to be a high growth startup and you really want to attract a certain type of venture capital, then perhaps we're going to structure your business a certain way. Or do you want to keep it small, just you? You don't want anyone else to join the team. You know that. You don't have any plans for expansion. Okay, well, maybe then we're going to structure you as a different type of entity that's more easy for you to run. So in incorporating, always you're going to go high level and think through the strategy decision of what are my long-term business goals and how should I structure my entity accordingly. Some other important questions you want to ask yourself is, who is managing the entity from an administrative standpoint? If the company is just you, that's fine, but you've got to add some important things on your calendar once you do incorporate. For example, your annual filing. If you are a more complicated entity type, maybe you'll need to be regularly editing your governing documents. Maybe you will need to keep notes on corporate resolutions. Who's doing this for you? Are you delegating it? Someone needs to be handling it. And then other questions you should think about, what liabilities and risks are most likely to factor into your business? What are you trying to protect? Why does the limited liability shield, how can it help you? Are you sitting on a lot of personal assets that you really don't want anyone to get? Are you, maybe a college student who doesn't really have any personal assets and you're not worried about it at all because there's not really anything for anyone to take from you? Do you intend to work with a lawyer? I'm not saying that you have to, plenty of people don't. But if you don't, then you need to understand the rules and regulations surrounding the entity type that you select. Because, of course, we can't abdicate our responsibility to understand the law. So if you don't have a lawyer in your corner, that's fine. But then when are you planning to sit down and read the Florida Corporations Code? A nice little bit of light reading. When are you working that into your schedule? Where are you going to find it? All of these important things you should be thinking about as you incorporate. Usually, folks hear these different terms. Well, I'm a sole proprietor. By default, in our state, if you don't incorporate as any entity, so you don't fill out any forms, nobody does this for you, by default, you are considered a sole proprietor if you're doing business. This one's highlighted in red. We don't like this one. This one gives you no extra protections. You don't want to fall into the default camp. This is not the preferred way to go. If you Google incorporation, you will usually see for a small business, the recommendation is that you incorporate as a limited liability company, right? And that's not limited liability corporation. You want to make sure you get that C correct there. As an LLC, usually the recommendation is coming from the fact that it is the least formal entity type. So you're not going to have to do much in terms of the consistent upkeep with things like resolutions every month when your board meets. You don't have to worry about that type of more strict paper trail as an LLC. That's why it's usually recommended. But understand that selecting the appropriate entity type is usually a multifaceted analysis where your lawyers are participating and the business operations team is participating, and your CPA is a really important player in that too, because there may be different tax exposures to you based on which entity type you select. And of course, we always want you to be protected legally, but if there is an option, all things being equal, for you to be both protected legally and save the most as you can with your year-end taxes, well then of course that's the gold standard option we want for you. So you definitely want to loop in your accountant to this conversation, but understand where there is a line. Your accountant should not be drafting governing documents for you. That's just not really the role of a CPA unless they have a law license. So while they may file paperwork on your behalf and at your direction, they're not necessarily administratively going to keep up with the entity for you. Okay, if you want to go with the DIY option, I've just placed some quick steps in here, and perhaps I can share this with you all. But for Florida, in any event, the process of incorporating an entity is fairly straightforward. You would go online to Florida SunBiz, and you see that they have a very user-friendly form. So if you knew for sure that the LLC was where you wanted to go, what you wanted to do, you would select the appropriate registration option for the LLC, and then it would prompt you with what you needed to input. You're going to need to input things like the name of the entity, make sure no one else is using it in the state. You're going to need to input your mailing address and then also a registered agent. So where are you going to receive important paperwork? Let's say, for example, the company is sued. Your registered agent would accept that on your behalf. Your registered agent can be a lawyer, a CPA, an outside company that offers this to you, and you yourself can be your registered agent here in Florida, but your registered agent can't list a PO box. So if you don't feel comfortable putting your personal mailing address publicly available, then you want to kind of think through who would serve in this role for you and for your company. There are a lot of websites that offer to do this for you, maybe LegalZoom or one of the other ones, and they want to charge you $80 or $300 or whatever it is. I highly recommend against that. Most of the time, those folks are not attorneys, and they're just paying you to fill out a form that you could fill out yourself. Florida makes this process very user-friendly, and if you're comfortable with the strategy behind the entity selection, then I don't think that you should pay someone else to fill out the form for you. This becomes less true when you are creating more sophisticated entity structure. Perhaps you're opening a lot of different corporations in order to position them separately and apportion liabilities, in which case maybe your legal team might do this for you. But if it's just a simple small business structure for an LLC, again, very user-friendly, save some money by trying to do it yourself if you're comfortable with that. And remember that step 5, even if you do take the DIY option, it is going to require some continual maintenance once you register the entity. And some of the fees for missing the deadline can be upwards of $400. So they can be pretty stiff. So you want to be careful about that. And then lastly, a lot of the recommendations that you hear are, consider Delaware as the place where you incorporate your entity. Definitely don't incorporate in Delaware just because somebody told you that that's something you should do. This is, again, a strategy decision. For some tech companies, it makes sense to position themselves in Delaware because that's what their prospective investor pool might want. But Delaware can be expensive. It comes along with a specific Delaware franchise tax that can be scary and misunderstood sometimes for folks. And so while there are certainly pros for registering in Delaware, we want to be strategic, like everything else that we do for our business, in deciding which state we incorporate in. A lot of the time, the appropriate state to incorporate our business is the state that we are operating in. So if you're primarily operating out of Florida, usually that's a perfectly fine option to go with. And I wouldn't break that unless you had a very good reason to go with another state. All right, so the takeaway on incorporation is that when this process is performed by sophisticated entrepreneurs, it's a process that includes a multifaceted analysis, starting with high-level strategy and thinking through things like tax and consistent administration. Okay, I'm going to skip through these and come back to them if there are any questions about incorporation at the end. Let's roll on through to IP, intellectual property, a really important piece. And we're really pulling an IP from general concepts of Property 101. Property, I'm going to skip over because most of us understand it inherently, right? If you own land, usually you've got all the paperwork to back it up. If you don't, this concerns me. If you're entering into a lease, most of us have usually done that before. If you have physical hardware, tangible things, this is all your property. But where I notice it starts to get a little bit fishy for the small business owner is when we're talking about the intangibles. What about your digital assets? What about photos, your website? What then? And this is all the realm of intellectual property. It's certainly true that your digital assets and your IP can be an actual asset, right? A line item that helps you. But you got to make sure that it's protected. And as you are investing into things like the development of your brand, your logo, your marketing efforts, how are you ensuring that that investment is safe and it is protected? And so when we talk about IP, we're usually considering three special buckets: a trademark, which a lot of us think about when we're putting together a logo or a name of a company that's unique; copyright, if we're thinking of a book, for example, the book would be copyrighted so that somebody else doesn't just come and create, a version of Harry Potter, right? We can't do this. Harry Potter is copyrighted, it's protected. We can't create the exact same duplication of it. And then we think about patents. If you design and engineer something unique, how can you ensure that it's yours and that there is some kind of certification there ensuring that your unique specifications belong to you? Usually for the small business, we're playing more with trademarks, and we've got to think about IP and ownership from the standpoint of, let's say you're doing it yourself and you're creating a website. Well, the pictures you use, in a very oversimplified sense with IP, the creator of the thing owns the thing. So I'm going to say that again. This is, again, oversimplification. The creator of the thing owns the thing. So if I paint a picture, IP says I own it. If I'm a photographer taking photos, I own those. And so on and so forth. If I'm a writer, if I'm a poet, etc. But this issue starts to blend with contract law. What happens if I hire you to write for me? What happens if I hire you to take photos for me? Or I hire you to create a website for me with some unique designs. And this idea is what we would refer to in contractual language as a work for hire agreement, perhaps, an IP transfer agreement. Sometimes these can be standalone contracts or they can be provisions in an overall contract, but they're really important because if you don't have contractual language actually transferring over the ownership, the default rule that I told you all is what's going to apply. Creator of the thing owns the thing. I assure you that there are situations where folks are paying $50,000, $100,000, for them, a big investment in their business, to creative design firms to produce for them a website or a platform, and they're doing this without ever signing any contracts. And then when issues come up, the default rule applies. And so even though there was a work for hire in theory, if it's not actually written out, the person who created the thing owns it, and you're just kind of fortunate to use it, which is not the situation you really ever want to be in. So make sure that you own the things you think you own as a small business owner. All right. And as you are incorporating, or if you're past that stage and you've already incorporated, make sure that your business name is trademarkable and that it isn't otherwise already being used by someone else who's doing a similar thing. Again, with the DIY options, you can, of course, check Google, but another good place if you want to register for a trademark is the United States Patent and Trademark Office website, so USPTO. You can just Google it. They have a search engine there. It's not the most user-friendly, but you could still run a basic search to see if anyone else has applied for, has currently, or has had in the past a trademark registered for the name or for a logo similar to maybe what you want to use. It's an unfortunate thing to see a small business invest a lot of time and money into a name they're excited about, only to get a cease and desist letter telling them they need to stop using it. And at that point, if the cease and desist is accurate and they're not going to fight it, which can be a costly exercise, then they need to start from scratch in terms of branding, in terms of correcting the error, and that's a loss on the company books, right? So we want to make sure that we think through those things and that we're using those to the best that we can as small business owners, to the extent that you are investing your time, your money, your resources in building a brand that you want to be recognizable. Well, then same thing. You want that to be protected, and you don't want someone else to kind of come in and take advantage of that with a copycat scheme. And the more effective way to protect yourself in that instance is to have the appropriate trademark and to use the law to your favor to stop others from maybe taking advantage of the goodwill you've built around your own brand and your own company. All right, I also have a slide here with questions and things you should consider in terms of how you should go about thinking through investing in your IP. A lot of times the questions that we get from the small business owner is this something that I should invest in right now? It's only me, I've not invested that much money into it. Do I need a trademark now, or do I need a trademark 2 years from now? When's the right time? And here it's a proportionate analysis. How important is your name to you? How important is your logo to you? How much are you investing in developing it? And how are you going to feel if someone tells you to stop? Same thing is true for all types of IP. So you want to think through those things as you're deciding whether or not it makes sense for you to invest in protecting the IP. All right. Rolling right along, contracts, which we already started touching on and which is an important thing to consider. All of these elements of business law blend and work together. So it's usually not the case that if you have one trademark, well, then there you go. The rest of your business is protected. Unfortunately, it just doesn't work like that. And so contracts are really going to be the epic shield that protect your business in a lot of ways. And contracts are living documents that need to be updated over time based on changes in law and changes in your business operation. I'm going to skip through some terms and just give you some high-level takeaways, because I understand that most people, the eyes glaze over when we talk about contracts. I understand most people don't want to read them. For me and my team, we enjoy doing it. We are happy to read your 100-page contract so you don't have to. But what you need to know high level as the business owner, in general, you should codify your relationships in writing. If money is moving hands and you don't have a solid sales agreement for you and your team, this is a problem. Usually it's the first contract that we recommend a small business invest in. You're selling something. Everyone, it's a little bit different, but perhaps, in this example, it's services with regard to press, to PR, to marketing, what have you. Fine. The details, the terms of the relationship and what the consumer is buying and the bounds of what you're giving needs to be clearly laid out in your contract. And this doesn't have to be a divisive thing. This doesn't have to be a nasty thing. The point is, both of you should understand this so that you can avoid issues in the future. And from the standpoint and the perspective of the small business provider, a lot of times what we observe is that they want to go above and beyond, and they don't want to scare the work away by giving them a contract. But then the kindness can be taken advantage of in terms of, perhaps I agreed to provide you this deliverable, and I budgeted in my mind for the business that it would take 10 hours. Well, if you don't have those clear lines drawn in the sand and the client follows up with an additional 30 hours worth of revisions, edits, changes, questions, this can tank the business because it's not what was agreed to, not the appropriate amount of money that changed hands, and things like this we would want to consider in our contracts. Of course, the contract itself is not going to stop your clients from asking for more and more of you. You have to then back that up with your business operations. But it's certainly a good starting place. And if you don't have one, something that you should definitely consider putting together. Again, contracts are the shield that protect your business. I feel a certain kind of way about template contracts, but I hear this from clients a lot, so I'll address it. And that is, well, we don't need a contract because I found a sample that I think looks good off of Google. Okay. I feel a certain kind of way about this because contracts that are powerful protection for you as the business owner or as the consumer, if for some reason someone was writing it for you, they're custom. They're created with your business goals in mind. You understand the miscellaneous terms, and there's a process behind it. Template contracts are not custom. They're templates. Good lawyers use templates without you having to tell them. A lot of clients, because they're perhaps scared or they don't know the process, they'll give us a template and they'll say, hey, maybe you could use this to keep costs down. Great lawyers are going to do that anyway. Firms who write contracts for a living usually have a whole database of contracts, and they're not charging you for the template. They're charging you for the customization of the template based on your needs. So some things that are kind of rookie to say to a lawyer are, maybe things like, I just want a simple agreement. For a lawyer, this is like nails on a chalkboard, because we want to produce for you gold standard, and however many words or pages is required to protect you, it's our job to do that. So in a way, this question is asking your legal team to create for you a shield with holes in it, which most good lawyers are not going to want to do. But on our end, we're very sympathetic and have empathy for the client standpoint. And so whenever we get comments like these, we're trying to think through, all right, what is it they're trying to say? Why is it coming out this way? And how can we kind of create a synergy between what they're saying and the protection we know that they need? Usually when someone says simple agreement, what they mean is, I don't want to scare my client away with a 20-page monster. And there are ways to create contracts that are separate and in pieces and that don't seem so scary, but that still have all of the things in there that are needed to protect you. In general, a contract's going to have at least two parts: the essential terms, and then usually at the end, boilerplate or miscellaneous provisions. And what I've seen a more rookie entrepreneur do is try to cut all of those out at the end. Maybe you're editing your own contracts. Again, I don't advise it. Maybe you're editing a lawyer's contracts and you say, well, this is miscellaneous, so I'm just going to delete it all. Not recommended. All of those provisions, when they're done correctly, are the product of an analysis of changes in law and legal opinions by judges that maybe are relevant in your state or at the national level, or just good practice in the industry. And so cutting them is a very, very dangerous thing to do. So in general, we don't like template agreements because they are not custom to you. It is true that there are some industries that have standardized agreements, in which case we'll just put an asterisk by those. You see this, for example, in the real estate industry, in the insurance industry, where sometimes committees or formal bodies come together to put together streamlined agreements in the industry, in which case those get a special asterisk. And I'm not saying that those templates are bad. I'm saying poaching a template from a competitor or from a friend or from Google, not the way to go. And also paying for a template that's just customized by some bot, inputting your name and maybe what you're charging clients. So for example, on LegalZoom or others, I don't think this is a good use of your whatever you have budgeted for legal, because that's not the type of customization that I'm referring to. So in general, the first place in contracts we recommend you start as a small business owner is the sales agreement. And then other things to consider, and that you've probably seen, are going to be terms and conditions, privacy policy. Are you hiring independent contractors to maybe work on something for the company? You want to have an independent contractor agreement. How sensitive is the information that you're providing? If you're working with medical service providers, legal service providers, you know that there are all these rules that restrict what they can do. You may come into contact with sensitive client files. And then if you pass that on to independent contractors, well, now you're at risk and you're putting their company at risk. So you've got to have some kind of alignment between how information is flowing, how it's protected, and especially now in the digital age, how secure are things? Are you sharing passwords? Is cybersecurity an issue? And again, this is going to be how much you invest here as a small business owner, proportionate to how sensitive is the material and how important is it to you. All right. And lastly, I will note, and then I will move on from contracts, don't overestimate your relationships. We see this a lot with the small business owner. And I realize most small business owners don't enjoy working with lawyers because lawyers tend to appear negative. And I'm not approaching this conversation from any negativity at all. It's certainly my hope and my firm's hope that whoever you're doing with business with has all the best intentions in mind. But usually what we see is folks so terrified to even have a conversation with their partners, with their co-owners, with the people on their team, that they don't do anything. And then there's nothing in writing and the conversation is never had. And then you've got to default into, well, this is what we spoke about, which is risky, or this is what the general default law tells us to do. Contracts allow you to adjust that. And so I would highly recommend you approach contracts from the mindset of it's not a mean thing to ask someone to sit down and think about the terms of your relationship at any point, whether it's from a sales standpoint or whether it's from a hiring standpoint. You have to understand what you're buying, what you're getting. And I don't think that there is anything negative about that conversation. And the risk of overestimating your relationships can be very high for a small business owner. We're working with a client right now, small company, small marketing firm, husband and wife owned. They hired a team member. She was there only 8 days. They realized she didn't have the chops to do what they needed her to do, fired her, and they've literally been in a lawsuit for almost a year now, have spent maybe over $30,000 on legal fees for a team member who was making $30 an hour, who sued them claiming that an official employment contract was created guaranteeing her employment for the long haul. Really, the moral of the story is they overestimated the relationship. They thought they were bringing somebody on who would feel more comfortable with being asked to leave than she was. They didn't have the appropriate paper trail, and this team member who was only there for 8 days has caused a year-long headache and an expensive one. And so you really want to think through these things. I'm going to skip through these because I think I covered a good amount of this, and that creates a good segue for us into employment law. There is a lot here, and I'm not going to be able to cover it all. In general, what you should understand is that the default rule in the US is that employment relationships are at will. So you hire someone, and unless you're terminating the relationship for a protective reason, you as the employer are allowed to terminate the employee for just about anything or no reason at all. That's the default rule. Things can exist to adjust the default, like a contract. An employment contract guaranteeing someone employment for a year adjusts the default. In the universe of employment law and hiring people, what you should know as an owner is that words matter a lot. Referring to a team member as an employee versus an independent contractor, big deal. Referring to someone to providing a team member an employment opportunity, the language around your offer letter, the language around their acceptance of the offer letter, all of that could be used in a litigation in a way that maybe you don't realize how important it is. You know, how might a judge perceive the language of your offer letter? Does it look like it's guaranteeing this person employment for the long haul? If you're not sure, it's just telling you that that's something you need to have a little bit more knowledge around. Read up on it, make sure that your DIY efforts with employment don't come back around to scare you. For the small business, usually we don't see as many full-time W-2 hires. Usually we see more of independent contractor relationships. This is also a place that creates a little confusion because while employment contracts mean one thing, independent contractor agreements, which are also contracts, mean something different. And we do recommend an independent contractor agreement with every independent contractor you're working with. This is further compounded by, even if you have a contract with your independent contractor, that doesn't necessarily guarantee you or them classification as an independent contractor. What I mean by that is different federal agencies, different state agencies have their own tests as to whether or not a team member, a staff member, is correctly classified as an independent contractor. Some of the tests are like 15 parts, prongs, 20 parts or prongs. There's a lot of details and nuance to it. But essentially, an independent contractor should have freedom in terms of their schedule. They should have freedom in terms of the tools that they use. Uber had a lot of issues with this and a lot of litigation around it. Are Uber drivers independent contractors or are they full-time team members? Well, they're using their own cars, but maybe they have a defined schedule with Uber. And so it's a little bit difficult to assess whether or not your independent contractor, whether the IRS, for example, would agree that you've properly classified them. And that's an important component because if you have been avoiding the tax exposure that comes along with classifying your independent contractor as a W-2, and the IRS decides they disagree, well, they can step in and require you to pay the taxes that you owed and any additional kind of penalties surrounding the relationship, even if you've got an independent contractor agreement, even if the contractor themselves wanted to be classified that way. IRS won't care. And so you really want to make sure in general that you understand these terms to make sure that you're protected and that, of course, the independent contractor is protected. There is a lot more in terms of different federal rules, different state rules. So the I guess last takeaway I'll say for employment law is as you get to that exciting place where you get to grow your team, proportionately the risk associated, it increases. The exposure to your business and the amount of landmines that you're now facing in this new exciting terrain as an entrepreneur, they double. So what needs to happen is that the investment in whether it's legal or education, if you're going to DIY, which I don't recommend at all, It needs to increase proportionately with the level of risk, because issues here in terms of litigation or penalties from different agencies can bankrupt a business that's growing. So you really want to be careful there. I think I covered most of this. And I want to leave it open so that there's time for questions, Annette. So if there are questions, I'm happy to cover. Otherwise, I'm happy to chat about dispute resolution.
Great, and I think we're an intimate group that we can ask the questions if people want to go off mute, or we can go ahead and put them into the chat. I know I had a question about something that comes up in our group a lot, is the need for errors and omission insurance. So I know you talked a little bit about liability, but liability insurance, and should that be something that we consider as contractors or solopreneurs, and when in our journey?
So great question. And in general, lawyers are risk averse. So usually our answer to most things is invest in all the protection as soon as you're available, as soon as you can. The sooner the better. And so lawyers like the idea of insurance because you're going to invest what is a relatively low dollar value for what could be a great amount of protection in the end. If, let's say, you have $1 million policy limit and you're paying whatever X is for the policy, the insurance, coverage, if it's triggered, is going to cover you in the event that you have to indemnify the other party, in the event that you have to hire an attorney. It would be a lot nicer to have the insurance company paying your legal fees as a company, as opposed to you paying those legal fees out of pocket. So in general, I think most lawyers are going to recommend you get insurance sooner rather than later. But taking aside the gold standard response, I'd say, and this is the trend in the presentation, proportionate. The more risk associated, the higher you should consider insurance. For example, we've represented folks in the railroad industry. Their insurance is astronomical, but to operate without it would be absurd. They're moving across state lines, hazardous chemicals, and those trains can fall off the track, which is actually really costly to reset. And so investing in the insurance is just a no-brainer. Whereas my sister, she's not a railroad, she owns a small salon and she cuts hair. But when she was in beauty school and learning, she accidentally cut someone's neck. And that's the type of thing that insurance could help you with. What if you hurt someone in the process of providing them a service? Well, $10 or $15 a month for her, the insurance cost is very low, is worth it to pay for the peace of mind that your carrier would step in and cover you in the event that something goes wrong. So in terms of the errors and omissions, and I'll say in general for the small business, we're usually looking at some version of a commercial general liability policy, and you'd want to work with your insurance provider or your agent or broker to see all of the different coverage types that would make sense for you based on what you're doing. You want to, I'd say, over disclose in the underwriting, not attempt to get your cheapest type of quote, because if you don't disclose everything in the underwriting, then that could be a reason why you don't get the type of coverage that would protect you in the end. And insurance at its core is just a contract. So you want to make sure that you actually have a copy of the contract. Most insurance carriers only give you a little marketing material with a bullet of the types of coverages you'd want to get, because they don't want to scare away their consumers, or because they don't want their consumers to fully read. I don't know. Always make sure you request a full copy of the contract. There's actually statutory law in Florida requiring your insurance carrier to give you the full contract because they fight it tooth and nail. So you want to make sure you have the full copy of it. If you're in the middle ground place where I don't really see a lot of risk, then it's going to come down to a personal decision on, are you a person who wants to roll the dice and not invest the money in having the coverage, or do you want to be more safe than sorry, which is more of a kind of personal business decision than so much of a legal one. In general, if you can afford it, I'd recommend get all of the coverage and get it sooner rather than later, because you just never know. So sorry, that's a long answer, Annette. I hope that answers.
Yeah. We also have a question in the chat about copyright updates. So Rosemary's asking if she makes updates to her website today, for example, should she change the copyright to 2021? And if she does a new download tip sheet, would that have to have the 2021 copyright?
Well, has she applied for actual copyright protection?
Hi, let me jump in. No, I have not, because I keep records of all of my authorship. So
Okay.
if I create a blog, of course that comes from my hand, right, from my pen, so to speak. So I have that trail. All the content is generated by me. So do I have to protect that? I thought that there was certain protection based on a paper trail of its origin.
Sure. So by default, you as the creator of the thing own the thing. This is my very simplistic way of saying of discussing IP. So you as the creator by default own it. I don't disagree with you on that, and I think it's great that you're keeping a strong paper trail. Phenomenal. If you wanted to take the ownership to the next level, gold standard protection would be then filing for actual copyright protection.
Okay, but then does that have to be done each time there is new content added? For example, I am changing a lot of the pages on my website. So then for each change, does each change then have to have its own protection?
Depending on the change and how material it is, yes. So here it's usually going to be one of those things where you invest in. If having some theft of the content that you're creating would have a strong impact on the business. So if you are a business that has designed, let's say, proprietary workshop, that you're going to then give license access to use, and it would really affect your business if someone duplicated that and just started using it. This is your proprietary material that you're trying to insulate and protect. There, we might copyright some of the work to allow it to be easier for you to file a lawsuit if somebody copies it. You don't see as many folks actually getting official copyright protection on text within their website because you're making it publicly available for everyone to see, and you're not usually charging a premium just to look at it.
Right. Yeah. No, interesting. Yeah, I may need to consult you regarding licensing on workshop content, because that is something that is very easy to basically steal. But this has been very useful. Thank you for your answer. I appreciate all the insights.
My pleasure. Thank you.
Another question, so you talked about independent contractor contracts and also client contracts, but how about, coming from a big agency previously, we would do a lot of contracting for influencers, for content creators on behalf of the clients, right? Because kind of going through a big CPG company's legal process would slow us down, right? So our clients would have us say, like, on behalf of Post's Cereals or Amazon, we're contracting these people, but as solopreneurs, probably we don't want to take on, that, I don't want to say burden, I don't know what the legal term would be, but it's a big responsibility, right? So should we be having our clients issue those contracts for any type of contract work, any content creators, event sponsorships? That's also something in the past that at a big agency we did, under the agency. Is that something, or kind of having a contract in place that says, culture-wise on behalf of its client X goes into this sponsorship? How are we protected then?
So are you talking specifically about, culture-wise, or just an entity that would be similar, or protecting the influencer?
No, I'm talking about protecting us in that. Like, should we be kind of pushing our clients to issue those contracts directly from their entities? or, you know, as long as we have in there on behalf of our client, if we're issuing the contract, does that still protect us?
Who is paying you in this example?
The client pays us for the service, right, to come up with the recommendation, manage the influencer relationship, kind of give them their scope of work of what they're creating, making sure that they're meeting their deadlines and kind of posting when they're supposed to, working with the influencers to get the analytics of this is just one example, right? I think we work in a lot of different ways. So we're managing all of that. I think now as a small business owner, I try to get my clients to pay them directly, pay the influencers, or they have to pay, you know, my entity in advance when they reach a certain amount of out of pocket. I don't want to be front loading that. But does it matter who's paying, or is it more like who's the contract is with?
Well, if it's protecting you, then it matters who's paying you, because we want to make sure that that relationship is spelled out clearly in writing. And then I'm trying to fully to appreciate the question. And so it's if one of your clients is having you engage an influencer,
Yes, exactly. To create content for the client.
then we would want you to recommend in a, you're not giving legal advice, but best practice way, that if you're working with an influencer, we need an additional agreement to ensure you're protected and, in a way, ensure you're protected. Because if the influencer is supposed to secure a certain ROI for your client that you're kind of promising in a way or helping to facilitate, then, you know, you're going to kind of step in and manage that. And you don't have a pre-existing relationship with that individual, or if you do, how is it spelt out? How is it ensuring that it's, you know, protective of your client's interest and not so much of the influencer? And it's interesting because some senior attorneys that I know, we've been trying to do more work in this space and educate people about it. And it's kind of like the wild, wild west, you know. A lot of influencers aren't sitting on their template contract or a contract that they use when they're asked to do a kind of social media post or what have you. And so we receive requests sometimes from very senior lawyers who are really good at what they do. Like, what do we put in an influencer contract? What should even go in there? And that we just did on Friday a presentation to a YouTuber conference talking with different influencers, and it was very cool. And there's a lot that's happened in terms of litigation for when something is promised and then it's not delivered. And we're starting to see that play out and get better best practices around what should be in those specific types of agreements.
Right. Yeah. I mean, formally, we had pretty in-depth. I mean, sometimes clients like the brand, like an Amazon or like a big CPG, wanted to leave it a little like loosey-goosey and kind of, you know, own the content in perpetuity, but then also make sure that they weren't working with competitors. So that aside though, but I'm saying in terms of, I don't know if the client isn't happy with the content, you know, they still have to pay the person for their time that they use to create it. At least that's what I believe, right? And so what, you know, I guess my question is, should we be entering into the contracts on behalf of our clients with the influencers, or pushing our clients to enter directly into contract with the influencer and then us just managing? And I think you kind of answered, have the client do it.
Well, okay. I'm for that one, I would say that it depends on what's your relationship with that client, though. To me, it comes back to that, because if it's more bespoke, if it's more white glove, and you are perhaps being paid hourly to manage something like this for the client, and they're okay with it, then I'm fine with it being between you and the influencer. But if this is a one-off, you do, you know what I mean, one press for release for these guys, and then now you have to invest all your time, money, and effort chasing down an influencer, no, that's on them. So I think it depends on the relationship with the client.
Okay, thank you.
You're welcome.
Does anybody else have any other questions for Kristen that you want to drop into the chat, or feel free to chime in?
There's also, I see a member of my team logged in. Hi, Charisse. Good morning.
Good morning, Charisse. I think this was great. I think it was a lot to take into, and I think that no matter where you are in kind of your entrepreneurial journey, it's always something, like I said, that you're going to need. COVID, really taught us that. As someone who's married to an attorney, he definitely saw an uptick of, we signed on to all these events happening in 2020. What do we do? Like, right? What was it? What's the term? Why am I totally spacing on the term for like events that you can't, force majeure, right? Yeah, and so many of those weren't in contracts or exactly clearly defined. It was kind of unprecedented.
Yeah. Exciting for us.
Exit sponsorship due to global pandemic. That didn't exist before.
Question mark.
But we really appreciate your time and kind of walking us through this. I know I took a lot of notes on things that I need to kind of evaluate for my business.
My pleasure. Thank you so much for inviting me and for organizing this. And thank you all for taking the time to listen.
Absolutely. And we did record it. And so we just launched our YouTube channel, and we'll kind of be sending that to some folks that weren't able to join us due to time conflict.
Awesome.
Thank you. Everyone have a great day.
Thanks so much. Take care.